Can a painter sue his employer under Labor Law 241 for falling down an unsecured plastic sheet? To find out, you have to read Bazdaric versus Almah Partners, but it's 19 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Bazdaric versus Almah Partners. The citation for this case is 2024 New York Slip Opinion 00847, published by the New York Court of Appeals on February 20th of 2024. The issue in this case is whether Labor Law 241 can be used by a painter who's painting an escalator and slips on a plastic sheet that's covering the escalator steps, resulting in his injury when he falls down. To understand and appreciate the context of this case, I think what's helpful background is, first of all, Labor Law 241, which states in sum and substance, 241 sub 6, says that all areas of construction, excavation, and demolition must be operated and conducted to provide reasonable and adequate safety to the persons employed there or frequenting the place. And the commissioner is allowed to make rules that the employer must comply with to make sure that the area is safe for the employees. And then we go to the next area that's helpful is 12 NYCRR 23-1.7D. These are the rules the commissioner makes. Under general hazards, slipping hazards, it says, employers shall not suffer or permit any employee to use a floor, passageway, walkway, scaffold, platform, or other elevated working surface which is in a slippery condition. Ice, snow, water, grease, and any other foreign substance which may cause slippery footing shall be removed, sanded, or covered to provide safe footing. So those are the two background pieces of law that I think is helpful to understand. The facts in this case are that plaintiff here is the painter. His name is Sreko Bazdaric. He's working as a painter at a project at a renovation site. I think it's inside of a mall. He was working for a subcontractor called Cara Painting, which was hired by the general contractor, J.T. Magan and Company, to complete a renovation project, which included painting the sides of an escalator. So his job was to paint the sides of a non-moving escalator. So he had to bring paint onto the escalator and paint it. And to protect the floor of the escalator, the actual steps, which was not moving, they put a thin piece of plastic sheeting. And this was unsecured, that he was required to stand on to complete the job, which would protect the escalator from dropping paint and protect him from slipping, theoretically. He complained to his contractor, Cara Painting, this was not safe, and they said you have to do it anyway. He then walked into the middle of the escalator, put down his can of paint, took a step, and apparently fell down, resulting in the 3-gallon can of paint hitting his leg, the paint can hitting him in the back, and his body falling down and hitting some of the steps of the escalator, the metal escalator, resulting in a disabling injury. He then sued a lot of different people. He sued the general contractor. He sued a bunch of different people under Labor Law 241-6, right? This is that you have to make sure that it's safe for your employees to work in the area. And he based it on that code I mentioned, 12 NYCRR 23-1.7D. He moved for summary judgment, which is basically I should win without a trial based upon the facts that are undisputed. He submitted evidence as to what he did and said and saw, and testimony from the general contractor subcontractor that the plastic is the wrong type of covering for an escalator. It should have been either wood or canvas, like a drop cloth. The defendant opposed summary judgment, and they said two different things. First, it doesn't apply here. They said the defense arguments were that it doesn't apply here because plastic sheeting is not like ice or snow or grease. So it doesn't fit into that section of what the commission defined as slippery surfaces. And second, they said the plastic was integral to the work. And third, that he was at fault because he's the one that agreed to do this and put down the plastic himself, even though the canvas was available. The trial court granted the summary judgment motion, said, you are right. Plaintiff, this was liability on the undisputed facts here. It goes to the appellate division and they reverse it. It then goes to the Court of Appeals. And the appellate division, when they reversed it on a maxim called adjustum generis. Adjustum generis is a general principle of statutory construction that says that if it's something else like the things that you just mentioned. So when you mention grease, water, ice, or snow, they say, well, plastic covering is not like grease, water, ice, and snow. It's not of the same type. That's what the Latin is, of the same type, of the same kind. So they had flipped it and granted summary judgment for the defendant here. It goes to the Court of Appeals, and they reassess everything. They say, first of all, with respect to the argument that Bazdaric it was his problem, it's his fault. No, they say Labor Law 241(6) creates a non-delegable duty on the employer to comply with the commissioner's rules. The owner and the general contractor are vicariously liable, regardless of their fault, if the plaintiff establishes it was a violation of the code. So whether Bazdaric was contributorily negligent or if he did anything to cause the injury, doesn't matter. Labor Law 241(6) is a non-delegable duty on the contractors to make sure it's safe. So then they go to the next issue, the next two questions, which is a plastic covering a foreign substance, just like snow, ice, grease, water? And they say that's the wrong test that the appellate division applied. It's not that it has to be the same exact kind of thing as water, ice, grease. The question is it foreign to the actual thing? Is it part of the escalator? No, it's not. Therefore, it is by definition, under Webster's dictionary, it is a foreign substance to the escalator. And as to whether it fits under that section of foreign substance, yes, because it shares with them the same property of being slippery when walked upon. So they say it does fit under foreign substance. And as to whether it's integral to the paint job, they say no, it's not. Some covering is integral. Some covering has to be used, but it doesn't have to be that covering. So the question on integral to the job, that is not a defense that can be used when it's not the ideal or it's an inherently dangerous covering. There were alternative coverings that were not inherently dangerous, like wood panels or a canvas drop cloth. And they grant the summary judgment back to the plaintiff, and that's the case of Bazdaric versus Almah Partners. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.